It is generally said that necessity is the mother of invention. In the case of intellectual property right, it is invention which became mother of necessity. Hello everyone, I am Krishika. Today I am going to tell you about intellectual property challenges in the publishing industry. We have divided it into three parts. First would be understanding intellectual property, then ethical consideration, and after that mitigating intellectual property risk. First we come to understanding intellectual property. What is IPR? Intellectual property rights or IPR are the rights given to respective people over what they have created. They give the creator of the idea or product an exclusive right over the use of their creation for a specific period. In the publishing industry specifically, the rights of author are protected by copyright for a minimum period of specified period. In India, it is 60 years after the death of the author. It established a legal framework to safeguard the unique creation of individuals, spanning a variety of intellectual endeavors such as literacy, artistic, and invention works. IPR grants creators the exclusive right to control and benefit from their creation for a designated duration. Now, I would like to tell you about different types of intellectual property. I have covered three. First would be copyright. This right applies to the literacy sector where publishing falls under. It provides the cover for author and right for their production. It also states that the creator can grant anyone authorization through a contract. This is where publisher can get exclusive access to the work to copy and release or make them available to the public. Next would be patent. Patent cover laws for an investors. The permit comes from a government body like the USA Patent and Trademark Office. It provides protection for work of the invention. This includes the design, production, and improvement of physical creation like machines. In a trademark, it ensures production of brand name and logos. As you know about Infosys and all other those IT companies or book authors, you would know that what trademarks are. It includes access to exclusivity, separating it from other products. Unlike the copyright, it ensures that creator can transfer access to the third party. It often form a part of business and brands. Trademark ensure that the brand name or logo can't be used by somebody else. There are impacts of intellectual property laws on economy. First would be industry regulations. With the intellectual property laws, industry regulations are changing. There are many challenges faced as new laws are arising, due to which we have to more paperwork. There are enforcement issues, like some firm want this to be enforced while others don't want to be, because those must be against their rules and regulations. There are online piracy challenges like threat to sales, impact on revenue, combating piracies. Now I would like to cover ethical considerations. We need to respect intellectual property rights. Those can be author rights, fair use, or plagiarism preventions. Fair use term was used in USA, fair dealing in UK. It allows someone other than the owner of copyright to copy, display, perform, and distribute copyrighted material under certain conditions without the permission. There are some factors for fair use: the purpose and characteristics of use, the nature of copyrighted work, the amount and substantiality of the portion of copyrighted work used. Fair use consideration: there are some fair use consideration. Fair use is permitted if the purpose is education, non-profit, news, criticism, parody, or satire only. It is permitted if amount of work used is small or moderate. Fair use is permitted if the author is lawfully acquired or purchased. There is no way to obtain permission. There are few copies of work. There is no impact on profit. We can prevent plagiarism by using measures and address plagiarism in publishing. There are some industrial challenges arising due to intellectual property rights. First would be infringement of copyright. In publishing industry, intellectual property right infringement is a problem that publishers and author must deal with on a variety of occasions. Most common among these are making infringing copies of the work for outside sale or hire, displaying infringement copies, publishing by a way of trade, distributing infringing copies of work for trade. Second would be rise in the digital environment. This is mainly due to the possibility that it may upset the delicate balance that exists between different interest groups around the availability and duplication of copyright contents. This disruption manifests in various ways. Some are seamless copying and reproduction. Copyrighted information can now be copied and reproduced considerably more quickly and easily thanks to digital technology. There is enhanced accessibility via the web. The web has facilitated access and reproduction of copyright material easier. Comparable quality to original. The quality of the copied material can be easily matched with the original. Then third is plagiarism. Plagiarism occurs when the originator of literacy work or an author presents someone else's work as their own, incorporating borrowed ideas, language, or any other element from another source without proper acknowledgement. This kind of blatant intellectual property infringement can be draining for publishing resources and energy, and it prevents the growth of the industry as a whole. Also, it happens online. Protecting creative works. How can we protect our creating works? We can license agreements. We can content security should be implicated. Emerging technology. There are various emerging technologies. In India, we have Indian Copyright Act of 1957 that protect original literacy, dramatic and musical and artistic work, and cinematography, films, and sound recording from unauthorized uses. Unlike the cases with patents, copyright protects the expression and not the idea. There is no copyright in an idea. Third section, mitigation intellectual property risk. There we can go for some legal strategies. First would be litigation consideration, understanding legal recourse available. Like we can, if we have some disputes, then we can go for laws available to us, like Indian Copyright Act of 1957 for copyrights. Then comes contractual protections, implementing contractual safeguard to protect intellectual property. Then third would be dispute resolution, strategies for resolving intellectual property conflicts. We can sit with other party and resolve our disputes verbally or with some conditions on paper. Then we can do industrial collaboration, like partnership. This can address common challenges which stakeholders are facing, and they can collaborate with industry. Best practices sharing effective strategy for intellectual property protection. Then is industry advocacy. We can do industrial advocacy as a profession also. Participating in advocacy efforts to strengthen intellectual property rights. It can strengthen our advocacy efforts. Then is future outlook. What we can do for our future of intellectual property rights. The first would be technological innovations. We can anticipate new impact of new technologies. What we are facing, what problems we are facing, how can we solve those. Then is adapting strategies. We can prepare future challenges by adapting new policies, new rules, new regulations. Global corporation. We can collaborate with international industries to address intellectual property challenges. That is for today. Thank you.